Good evening and welcome to our jurisprudence class. For the sake of orderliness, I have locked the mics. If you want to speak, please feel free and raise up your hand so that I release your mic for you to ask a question or to make an input to enhance the richness of the discussion. So I'm happy to welcome you tonight to the National Law School of Jurisprudence. And there are a lot of materials we have cited in the course outline. But if for nothing at all, we should read a chapter from MDA Freeman, Lloyd's Introduction to Jurisprudence, chapter 8 or chapter 9, or even chapter 10. The substance of the discussion on this particular topic remains the same. So it doesn't matter the edition that you are using. So try and read that. I think I've shared a PDF version of the Lloyd Jurisprudence with you. And there are also copies in the library. You can also procure your own copy if you can. So, in terms of natural law, the literature, some scholars will go to the extent of saying, and I think they are not far from right, that it is a label which has been given to so many ideas. Now, question is, do we have some unity in these diverse ideas which we have grouped together as natural law? So natural law, by way of opening, is not one theory. It's not one theory about the essence or the nature of law, but a family of positions united by the claim that moral standards or rational standards of practical reason are partly constitutive of legal validity or legal authority. In other words, natural law is not just one grand explanation of what law is, but then various attempts to respond to that. And within the various attempts, we see that consensus that if we are talking about what makes legal validity, we are talking about what makes law, or that which we should respect as being legally valid, then we cannot take out of that issues of morality. The fact that there should be some element of moral standards within whatever makes law, or whatever count as legal validity. So that is the point of consensus, which is shared by the various the explanations out there, which are grouped under the umbrella natural law. So if you take MDA Freeman's work, chapter 8, for example, he will start by making the point that there's a continuity of label and variety of meanings and purposes which have served different are served us in different periods. In other words, the natural law label has been used for a very long time, no doubt about that. And at the same time, there have been various responses or various explanations which are giving the label natural law. Yes, if you look at the variety of explanations constituting natural law, if you put them in the context of the various historical periods or the times in which those explanations come about, you begin to see that they serve useful purpose for the times that they come up. And as we go through some of the historical, development of natural law thinking, you begin to approach that. So therefore, if you look at the laws, they will frame the issues around three recurrent questions: source, method, and adjudication. In other words, are basic legal standards grounded in reason or nature. So, that which makes law law, do we locate it in reason or do we locate it in nature? Or that which makes law law is rather grounded in human fiat. That is law law because it's coming from a particular source within human institution. So that like parliament, for example, in terms of our constitution, is a lawmaking authority. If we look at our constitution, so should we say that if something comes from parliament as the recognized source of law making, then that should be the end of the matter? Should that put to an end any argument as whether it is legally valid or not? So that is the source. Then the other issue is method. Can we move from facts about human nature to norms? So if you say like the facts about human nature, the realities of human nature as to ideals or aspirations about us, what do you call the is ought question? The is ought question. The is it like the reality, the facts, and then the ought, the aspirations or the ideals. So, if you look at Lloyd's jurisprudence, you make the point that if you take scholars like David Hume, David Hume's, for example, will actually try and tear natural law apart, and that is why he said that it is like the Gallatin. And his attempt to tear natural law apart is rather based upon what he considered to be inappropriate methodology, which is available in natural law. That is the attempt to derive ought from is. So that is one area which, as we go through the various uh, responses within the natural law school, we have to keep at the back of our mind. Then the other third recurrent issue has to do with adjudication. Adjudication, dispute settlement. What follows for officials when enacted law is gravely unjust? So, if you are a judge, for example, you have sworn an oath to uphold the laws of Ghana, to do justice to all manner of people without ill will or affection, to uphold the constitution. So a particular matter is before you, and you look at the law, and you feel strongly that what the law is asking should be the position is absolutely wrong, is morally reprehensible. As a court, as an official, are you entitled to actually sidestep what the law says and do what is right? So that is the question. So what follows for official when enacted law is gravely unjust? So later on, when we are discussing scholars like Thomas Aquinas and so on, we come across things like less injusta non less est. An unjust law is not law. And we will begin to see how certain developments in the world, after natural law had gone down, those developments will revive the interest in natural law. And then we want to see the attractions of natural law and how it actually feed into some observation that an unjust law is not law. Less injusta or non-ex or less. So these are the basic things we have to keep at the back of our mind before we proceed. Now, what are the core commitments? Or what are the points of consensus? And what are the discernible fault lines, points of disagreement between the various schools? So, The core claim, like this, at the very minimum, we see this thread running through the various responses that there are objective reasons for action discoverable by reason. So there are objective reasons for action discoverable by reason or practical reasonableness. And these reasons condition the authority of human laws. So this seems to be like if you like the barest minimum of consensus between the various schools or the various proponents of natural law. That if for nothing at all, most of them will reflect the viewpoint that we have certain objective reasons as action, whatever actions there are, we can see reasons which can objectively be determined. And being lost with them, when we say objective test, you know what we mean as opposed to subjective, if nothing at all, from your law of contract in the first year. And also your law of thought, the reasonable man standards. And these objective reasons are supposed to provide authority or legitimacy for human laws. So therefore, if human laws do not reflect these objective reasons, which are discoverable by the use of our reason or practical reasonableness, then the human law will be lacking or deficit as far as legal validity is concerned. And that is the basic thesis, the basic argument of the National Law School. So, but beyond this core claim, beyond this consensus between the various proponents of natural law school, we can also discern or we can see fault lines, point of divergence within this marriage of responses. So what are the fault lines within natural law school then? So we encounter theological as opposed to secular. Theological, that is religious, as opposed to non-religious, secular. So at some point in time, we begin to see natural law thinking coalescing around two viewpoints. One saying that, yes, you need to have regard to God, convictions about God, the idea of God, in talking about natural law. And then we also begin to get some who coalesce around the viewpoint that we can talk about natural law without talking about God. So, from St. Thomas Aquinas, he is one of the prominent models of theistic teleology. In other words, he takes the view that God has a purpose. So teleology is just about like purpose, purposefulness. God has a purpose for creating the world, for creating human beings, and for putting the universe and everything in place. God has a purpose, and within the context of that purpose, we begin to discern certain principles which will feed into law. So we will come and talk about Aquinas in the course of time. And then we come across Hugo Grotius. Hugo Grotius, the famous father of public international law, in the famous work, Akbalum Ac Pacis, the law of war and peace. And beyond that, Grotius will come out with his famous methodology that even if God did not exist, natural law can still be conceived. Mind you, Grotius is not saying that he doesn't believe in God, okay? Uh, of course, we have a scholar like Spinoza and so on. Spinoza was a different scholar altogether, but we are not talking about his lack of faith, but we are talking about Grotius. So Grotius is making the point that natural law is inherently so valid that even if we don't talk about God, or you put it, if God did not exist, uh, natural law will still obey. And that is why no, MDA Freeman will tell us that we shouldn't treat Groucho's methodological approach or his hypothesis that even if God did not exist, natural law will exist, to mean that he was an atheist or he didn't believe in God. No, that is not it. And his move was more methodological, aimed at public reason for an international order. So, mind you, his interest was trying to develop international law, and just trying to say that, of course, even if we don't get everybody to believe in God, we can still talk about natural law. So that was the point that he was trying to make. Now, another fault line, or another challenge we have as we move on, is the issue of derivation. That is the direct deduction from nature. How David Hume will later accuse natural law scholars of trying to derive ought from is. And that is on the one hand. And so what do you mean by direct deduction from nature? No, some people will say that, okay, if we look at how the world is, the universe, the created world, we see certain realities there. And those realities should actually enable us to infer certain principles. And those are supposed to be like the principles of morality, which should guide law. And David Hume will actually uh, you know, sort of critique natural law as being guilty of what we call the naturalistic fallacy, attempt to derive the ought from the is. So let's keep that in mind. And we also have John Finnis, and he will say that we can use practical reasoning about basic goods. In other words, if we look at human beings, that God has made us to actually flourish, then there are certain things which are self-evident, which every human being should actually assess, enjoy. And if law is to be law, then law must actually make those basic goods, or those conditions of human flourishing possible for everyone. So we'll come and talk about that. And then again, we also see some faint convergence against ethic morality. So in the course of time, we will get scholars who initially were anti natural law, trying to bastardize natural law, for trying, in seeking to, you know, say that we cannot talk about a law unless law has morality. We have scholars, especially the legal positivists, champions like Professor Hart and so on. They actually critique natural law. But then, in the course of time, those who were strictly anti-natural law we begin to make certain concession that yes, law should have a certain modicum or a certain minimum amount of morality. Yeah, so we come and look at the highest and minimum content of natural law as against the survivor-based convergence, when John Finnis will argue for robust objective goods. So this is just an overview of what the natural law school is. We're now going to take our time and unpack them. So the natural law school, to start with, is concerned with how the legal system of a particular society is to be judged according to universalistic standards. In other words, how do we determine whether the legal system is good or bad, whether it is valid or not valid? According to natural law, there are certain higher principles of morality, which are universal, that is everywhere valid, unchangeable, and they should be the yardstick or the benchmarks with which we judge such uh, legal system or such law. So let's keep that in mind. Now, this is based on assumption that there can be deduced from nature certain objective moral principles, which can be deduced by reason, and which form a prescription for human behavior. So, therefore, what natural law proposes is that there are principles of law stronger than any human made, that is positive law. And for law to be valid, it has to reflect these higher principles. If law does not reflect these higher principles, then within natural law thinking, it will not be worthy of the label or the designation law. So let us keep that in mind. Now, in testing validity of law then, within the natural law school, what the law is should be based on a higher law dictated by nature or reason, and should be what the law ought to be. So what the law is not looked at on its own terms. It should be looked at with reference to a higher law, and higher law which is accessible or knowable by employment of our reason or by observation of nature, as it were. And for that matter, for the natural law scholar, what the law is not important as what the law ought to be. What the law ought to be is the crux of the matter rather than what the law is. Now, what do natural law scholars mean by nature? By nature here means certain principles which are so agreeable with the state and nature of man that a failure to observe such principles will necessarily lead to breakdown of society. In other words, there are certain principles which are so sacred, so essential, that if those principles are ignored or sidestepped, then we have virtually triggered collapse or breakdown of society. So natural law then is principally a theory of morality in general and not strictly a theory of law, if you look at it from that perspective. Now we would like to have a bit of like a historical excursus of natural law thinking. And if you cast our minds back for almost 3,000 years, what is natural law certainly has provoked various responses, and we would like to acquaint ourselves with some of these responses as it were. So we will start from the Greek philosophers, and I must say that the natural law thinking, if we wanted to do rare historical map, You can even go back as far back as the ancient, Persian, the Mesopotamia, because for as long as we have had human beings in this world, natural law thinking has been very much part of us. If we understand natural law thinking to be that there are principles of morality, and those principles of morality are eternally valid, universally valid, unchangeable, they can be known by everyone, then natural law thinking has actually been with us for a long time. But just for sake of representative historical search, we'll just use a capital selector and pick some few scholars. So we start with Plato, for example. As we know, Plato was a student of Socrates, and Socrates was a dark great scholar who actually did not write any book of his own, but then he gave very enduring and profound teachings. And his students, like Plato, would collect Socrates' teachings into his writing. If those of you who like philosophy, there's a work which we call the Trial of Socrates. Socrates, for example, had been he had this approach of inquiring into knowledge, seeking wisdom. He had a love of knowledge and wisdom, and that's what we call it philosophy. And his approach was to try and question, people on sustained basis on anything, with the view that through the sustained questioning and answers, we'll be able to develop knowledge by clarifying misconceptions and falsehood and reducing ignorance. That was his approach, and that's what we call the Socratic method. And, in the course of time, the people of Athens, Greece, actually had him arrested and he was tried. And his accusation was that he was corrupting the morals of the youth of Athens, because he was, imbuing the youth of Athens what they call critical thinking, and they began to have like a questioning mind and sought to tear apart certain long-held ideas. Now, when he was found guilty and sentenced to death, uh, Socrates, was kept in prison, and in those days, a certain ship had to arrive, return from a voyage, before he will be murdered. I mean, not murdered, before he will actually be sentenced to death. And he was supposed to be sentenced to death by drinking a certain poison potion, which is prepared for that. And later on, his students will try to arrange to have Socrates to be smuggled through the window from the prison, so that he doesn't have to actually, suffer death, because his students did not think that he had to actually be killed. He was a victim of injustice and hatred by society. But Socrates stood to his principle and said that if he were to actually to escape from prison and avoid death sentence, he will actually be defeating the very principles for which he had been teaching the youth. And because, in his view, it's the whole society that had come to conviction that he was wrong, he was violating their law, and he deserved to die. And if that is so, he had to face it. And if he were to do anything to escape, he will actually be running counter to the very thing they'll be teaching. That's very interesting. But that was just by the way. And Plato was one of his students. And Plato, I had what we call idealistic philosophy, and he will lay down foundations for much of subsequent speculation on natural law. So Plato, for example, would do his work, what we call the philosophy of forms, and so on, and he would develop the idea of justice as an absolute thing in itself, having qualities of truth and reality higher than those of positive law. So positive law, that is a man-made law. And he said that, well, there is something we call justice. And actually, he developed what they call like the philosopher king. Okay. He said that human beings, we are different classes. Some are just supposed to be servants, some are just supposed to do manual mechanical work, some are just supposed to be used for war, and others are just a selected individual who is supposed to be the ruler, and that ruler to actually do reflect and uphold what we call the idea of justice. He needed to be like a philosopher king. So it is within that context that he said that the idea of justice uh, is not just an absolute thing in itself. It also has the qualities of what? Of truth and reality, which made it higher than the positive law or the man-made law. So to Plato then, we know what justice is innately. That is, justice has inherent validity. Law must constantly strive to approximate to the absolute idea of justice. And ideal justice could only be achieved or fully realized in an ideal state ruled over by a philosopher king, capable of grasping the absolute idea of justice. So to know if a law is just, the philosopher king must look for qualities of justice within the law. And if he could not see the qualities of justice within the law, then the law is not just. So for Plato, only laws which pursue the ideal of justice can be considered right. If a law did not reflect or pursue the standards or the ideals of justice, then that could not be considered a right or a good law, as it were. Now we also have another student of Plato, who was Aristotle. And Aristotle also propounded ideas which actually fed into what we call natural law thinking. Now, unlike Plato, Aristotle pointed out that the source of ideals like justice can be found in human nature and is not an external absolute idea. No, Plato has created the impression that justice could not be assessed just by anyone, but you needed a special human being, which you call the philosopher king. He could use his abilities, faculties, to actually grasp the ideal justice. But Aristotle said that no, that is not the case. Justice is not external. Justice is very much within a human nature. And if it's within a human nature, then all of us are capable of knowing the ideals like justice. It was therefore essential to Aristotle to understand human nature because, in his view, understanding human nature could only be done by understanding man's purpose. We can only understand human nature if we understand the purpose of man. What is our purpose as human beings? Of course, those of you who are familiar with the Christian literature, there is a scholar called Rick Warren. He has written an interesting work called The Purpose-Driven Life. And I'm just mentioning that because of how it resonates with the methodological approach of Socrates on this particular matter, that to understand human nature, we need to understand man's purpose, man's teleology. So to Aristotle, man had a social and political purpose to live in a community and attain good life. And that is why, so there's something called the polis, P-O-L-I-S, polis. The polis was what we call like the city-state within ancient Greece. And the polis was supposed to be the ideal kind of society in which human beings could actually live and realize their full potential and have a worldwide life or meaningful life. And that is why that Aristotle will make the statement that no, you hear what they call a man is a political animal. It has to do with the fact that a person has to live like in the polis and participate in the life of the polis. So Aristotle makes the point that man had a social and political purpose to live in a political community that is like the polis and attain good life. And this had consequences for the law, which will help him strive to achieve such purpose. So this is how law comes. So if you look at it, trying to say that yes, man must have a good life. And if you can have a good life, you have to live in a political community. You have to live in the polis. Now, how can you then achieve the good life? You need to be supported. You need to be enabled, facilitated by a law to enable you to have that good life. So one of the consequences of this Aristotelian thinking is the emergence of the principles of natural justice. Mind you, the natural justice, of course, we will later on come to look at it in terms of adjudication, as we saw maybe from constitutional legal system, like maybe the fair, right to fair trial, hear both sides, audio terram partem, do not be biased or be a judge in your own cause. Nemo juris in causa sua. Yes, there are all some of the precepts of natural justice, but within Aristotelian thinking, natural justice is much bigger than that. So, Aristotle would say that principle of natural justice, which is common to all mankind, and is based on the fundamental purpose of human beings. What is the fundamental purpose of human beings? The state of goodness. The state of goodness. That is fundamental purpose of human beings. Now, before we look at the Roman scholar Cicero, Aristotle did the work, and he titled the work Nicomachean Ethics. So if you look at the Freeman's work, chapter 8, excerpts are extracted over there. And in his Nicomachean Ethics, he sought to develop the ideas of natural law and legal justice. Let me just say a few words. Quote, of political justice, part is natural, part legal. Natural, that which everywhere has the same force and does not exist by people thinking this or that. And he talked about the legal. Legal, that which is originally indifferent, but when it has been laid down, is not indifferent. Example, that a prisoner's ransom shall be a mina, or that a goat and not 2 sheep shall be sacrificed. And again, all the laws that are passed for particular cases. Example, that sacrifice shall be made in honor of brass cedars and the provisions of decrees. Now, some think that all justice is of this sort because that which is by nature is unchangeable and has everywhere the same force, as fire burns both here and in Persia. Why they see change in the things recognized as just. This, however, is not true in this unqualified way, but is true in a sense. Rather, with the gods, it is perhaps not true at all. While with us, there is something that is just even by nature. Yet, all of it is changeable. But still, some is by nature, and some not by nature. It is evident which sort of things among things capable of being otherwise is by nature, and which is not, but is legal and conventional, assuming that both are equally changeable. And in all other things, the same distinction will apply. By nature, the right hand is stronger, yet it is possible that all men should come to be ambidextrous. That is, our hands. The things which are just by virtue of convention and expediency are like measures. For wine and corn, measures are not everywhere equal, but larger in wholesale and smaller in retail market. Similarly, the things which are just, not by nature, but by human enactment, are not everywhere the same, since constitutions also are not the same, though there is but one which is everywhere by nature the best. So within that thinking, Aristotle was trying to say that there are certain principles which are the same or which are universally valid and which are unchangeable everywhere. So that is the point he was trying to make. And that is a takeaway from him. So now quickly look at the Roman scholar, Cicero. And Cicero advanced the explicit claim that the natural law provides universal moral principles, obliging not only Roman citizens, but all human beings. Mind you, Cicero was a Roman, a jurist, a Roman scholar, and a statesman. And his writings on natural law have been influenced by the writings of the Stoics, who propose that nature can be identified with man's reason. That if man lived naturally, when he lived according to reason, and the precepts of reason have universal force. Now, within Cicero's thinking, what was the test of a good law? It was whether the law accorded with the details of nature. And of course, these details of nature, as we have told from the Stoic, can be assessed by making use of our reason. So therefore, for Cicero, any positive law which contravene natural law ought to be struck down as an unjust law, because an unjust law is not law. In his work, he gave a very good description of natural law, and I like to quote from some of his writing. He has a work called De Re Publica. De Republica is the Latin. And this is what Cicero said, quote, "True law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. It summons us to duty by its commands, and averts from wrongdoing by its prohibitions. And it does not lay its commands or prohibitions upon good men in vain, though neither have any effect on the wicked. It is a sin to try to alter this law, nor is it allowable to attempt to repeal any part of it. And it is impossible to abolish it entirely. We cannot be freed from its obligations by senate or people, and we need not look outside ourselves for an expounder or interpreter of it. And there will not be different laws at Rome and at Athens, or different laws now and in the future, but one eternal and unchangeable law will be valid for all nations and all times. And there will be one master and ruler, that is God, over us all. For he is the author of this law, its promulgator, and its enforcing judge. Whoever is disobedient is fleeing from himself and denying his human nature. And by reason of this very fact, he will suffer the worst penalties, even if he escapes what is commonly considered punishment, unquote." So, in a nutshell, Cicero is trying to tell us that natural law are principles which are the same everywhere. They are not different in Ghana and different in Nigeria or different in United Kingdom or Kenya, Uganda, United States. Afghanistan, or Russia. They are everywhere the same. And that is why he said that we do not have one law in Athens, which is in Greek, and another law in Rome, which is in Italy. It's everywhere the same. And then he makes a very important point that natural law does not need to be published for anybody to know. Everybody knows natural law. Now, he makes the point again that we must all obey natural law. And if we decide not to obey it, we cannot escape the punishment of natural law. We can escape punishment of man-made law, but we cannot escape punishment of natural law. Now, just before we discuss Aquinas, there is also another scholar we call Justinian. And Justinian also developed some of the ideas of Cicero and some of the Greek thinkers. And he will make the observation that the law of nature is the law which nature has taught all animals. And this law is not particular to human race, but belongs to all living creatures, birds, beasts, and fish. And this is the source of the union of male and female, which we call matrimony, as well as of the procreation and rearing of children, which things are characteristics of the whole animal creation. So he will make the point, but as you will notice, he is developing natural law from Christian thinking. And if you look at some of the writings in the scriptures, for example, you also see some of these natural law thinking, the fact that we look at nature, how things are, and we can get certain principles which are self-evident there. But we leave that there and then come to look at a very important contributor to natural law thinking, the angelic scholar, St. Thomas Aquinas. St. Thomas Aquinas was an Italian Dominican friar or priest and a philosopher and a doctor of the Catholic Church. When you say a doctor of the Catholic Church, it means a scholar. It doesn't mean like a medical doctor. Someone who provide a clear teachings on God's revelation. That's a doctor. Now, Aquinas argued the case for a synthesis of law based on the premise that all things come from God, who is the highest form of good. Now, mind you, before Aquinas, we have had two streams of natural law. Those thinkers or scholars who seek to expand natural law with reference to God, and those scholars who seek to expand natural law not with reference to God or Christian religion, but just reason. And Aquinas came onto the picture and said that the two approaches are not mutually exclusive. In other words, it is not the case that if you are looking at natural law from the point of view of God or Christianity, then you cannot also at the same time look at it from the point of view of reason. You can actually marry the two and be able to provide an internally consistent explanation of natural law thinking. And That is why we are saying he makes the premise that all things come from God, who is the highest form of good. So that is a starting point for him. And that God created nature, which has an order. God is an orderly God. God is an orderly God. If for nothing at all, those of you familiar with the Christian account of creation in the book of Genesis, we are told that in the first day, God did this. In the second day, God did that. Third day, fourth day, after the seventh day. That in itself reflects for us a certain orderliness, a certain orderliness as opposed to disorder or chaos. So God is a God of order. So the existence of such order presupposes a reason. If God is God of order, he made things according to order, then there should be a reason why he made things according to order and not just in a chaotic fashion, as it were. In other words, there is a reason for the order. And on that note, Aquinas reminds us that law in all its manifestations flows from divine reason. So he will proceed to provide various classification of law. But before that, let me remind you that what we know about Aquinas concerning law comes from his work, Summa Theologica, in which he has a Cosciente to Cosciente 95, where he tries to develop his ideas on law. And the scholastic tradition at the time was what we call disputation. You ask a question and then you provide an answer. So, question 95, for example, question 90, he will be asking the general question like, what is law? Try and have a definition of law. And in that, Aquinas will say the following quote. I'm quoting, and these excerpts are in the Lloyd Jurisprudence, which I've referred you to. Law is a rule or measure of action in virtue of which one is led to perform certain actions and restrained from the performance of others. The term law derives etymologically from binding because by it, one is bound to a certain course of action. But the rule and measure of human action is reason, which is the first principle of human action. This is clear from what we have said elsewhere. It is reason which directs action to its appropriate end. And this, according to the philosopher, is the first principle of all activity. So this is the definition Aquinas gave of law. And he will continue to give some other ideas about law. For example, he will ask the question, who has the right to promulgate law? Then he will answer. Law, strictly understood, has at its first and principal object the ordering of common good. So look at it. So Aquinas is saying that the first object of law is how to order or how to achieve the common good. Then he continues, and I'm quoting. But to order affairs to the common good is a task either of the whole community or of some one person who represents it. Thus, the promulgation of law is the business either of the whole community or of that political person whose duty is the care of the common good. Here, as in every other case, it is the one who decrees the end who also decrees the means thereto. Unquote. Yeah, so just trying to tell us that yes, the whole purpose of law is to serve the common good. And when it comes to making law, either the whole community is making it or the task of making law is entrusted to one particular person or group of persons. Whatever it is, the law they must make should serve the common good. And that is why he has said that if you make the law, you decree the end, a particular outcome, then you should also provide the means of achieving that outcome. So Aquinas, after doing all this, we make the point that, quote, from the foregoing, we may gather the correct definition of law. It is nothing else than a rational ordering of things which concern the common good, promulgated by whoever is charged with the care of the community. So, in a nutshell, for Aquinas, the definition of law is the rational ordering of things which concern the common good, promulgated by whoever is charged with the care of the community. Unquote. Now, he will go ahead to now talk about the various types of law, the various classification of law. And in that regard, he identified this fourfold classification. Lex eterna, that is the eternal law. Lex divina, the divine law. Lex naturalis or ius naturalis, natural law. Lex humana, the human or the positive law. And what does Aquinas mean by the eternal law? Now, the lex eterna is the eternal law which reflects God's plan for the universe. So God has created the universe, the whole cosmos, everything which is created. God created it, both visible and invisible. It is known only to God, and all things, reasoning and unreasoning, are subject to it. So God has created everything, and he has imposed a law on what he has created. And this law he has imposed on his creation binds all things, things which have reason and things which do not have reason. They are all bound by this eternal law. So the broad general principles which mirrors God's plan for the universe comprise natural law. So the natural law is a subset, if we like, of the eternal law. So if we look at question 91 of the Summa Theologica, for example, Aquinas will say this, and I quote, as we have said, law is nothing else but a certain dictate of the practical reason in the prince who rules a perfect community. It is clear, however, presupposing the world to be governed by divine providence, that the whole community of the universe is governed by the divine reason. Thus, the rational guidance of created things on the part of God, as the prince of the universe, has the quality of law. This we can call the eternal law. So that is the eternal law Aquinas is talking about. Aquinas also talks about the lex divina, that is the divine law. The divine law. And the divine law is part of the eternal law as revealed through the scriptures. So, God's revelation to the human race, as we have in the sacred scriptures, is a divine law. So, the Decalogue, the Ten Commandments and all the things we know in the Bible, the Beatitude, blessed are no peacemakers, they shall be called children of God. Blessed are merciful, they shall receive mercy. Blessed are pure heart, they shall see the love of God, love of neighbor. These are all part of divine law. It serves to overcome the limitations uh, of law known through human reasoning. So it is God's positive law for mankind. So if you like, God's man-made law for mankind in concrete situations. And with respect to this, like the lex divina, if you cast your minds back to writings of St. Augustine, he too contributed to natural law thing, but we cannot talk about all of them. We just skip some of them. In his famous City of God, he will talk about the fact that when God, created human being, he everything was well and good for us until our first disobedience, Adam and Eve, and then we fell short of God's glory. We are prone to evil and all that. And for that matter, God wanted to bring us to the ultimate destination where we restore to our original position of privilege of grace and enjoy Him. And we cannot get there ourselves. So God revealed Himself and tells us what we need to do. And that is founded in what we call like the divine law. So that is another way by which Augustine wants to explain that. Then Aquinas also talks about the lex naturalis. The lex naturalis, that is the uh, natural law. And the natural law within Aquinas thinking results from the participation of rational creatures in the eternal law through the operation of reason. So we know the eternal law is God's law for creation, for the universe. Okay. Now, Aquinas is saying that when rational creatures, that the human beings, we use our mind to participate in the eternal law by extracting principles from the eternal law through the use of our reason for our everyday living, then that is the natural law. So by reasoning, man comes to know that the fundamental precept of natural law is to seek good and avoid evil. So every reasoning creature knows that fundamentally we have to seek good and avoid evil. Every human being knows this. Your conscience will tell you. So this fundamental precept, that is seeking good and avoiding evil, according to Aquinas, is self-evident. When you say something is self-evident, it means that it is by itself compellingly valid, that you don't need any further proof. You don't need anybody to convince you that it is true, it is valid, as it were. Therefore, man's participation in divine reason leads to the first precept of natural law. And what is that? Self-preservation. So self-preservation is the first precept of what? Of natural law. And what is self-preservation? The inner impulse or quest in each of us to protect ourselves from destruction, protect ourselves from dying, protect ourselves from harm. That is a self-preservation. And it is something which is deeply ingrained in everyone. If there is danger, instinctively, you do everything to try and avoid it. If something is going to end your life, as far as lies within your power, you do everything you can, even if it will not be successful, for you to try and avoid it. So that is all part of self-preservation, which is the first precept of all natural law. So this necessarily means man has an inclination to good according to the nature of his reason. And anything which accords to the precept of self-preservation, that is inclination to good, belongs to the province of natural law. For example, avoiding ignorance, that will certainly belongs to natural law. To live in a community peaceably with others belongs to natural law. Avoiding harm or not to cause harm to others also belongs to the province of natural law. Then he also talks about less humana, that is man-made law, man-made law, and also known as the positive law, which, according to Aquinas, derives its validity from natural law. Aquinas holds the view that man-made law is necessary because natural law does not provide all or most of the solutions to everyday life and need to compel humans to act reasonably. So for concrete situations in our day-to-day living, natural law may not provide ready-made solution because we need to contextualize the precepts or the principle of natural law in the realities of everyday living. And that is why human law becomes necessary. And this human law may be variable, may not be the same, may not be uniform, in accordance with time and circumstances in which it is formulated. But its essence is to be just. So man-made law may vary from time to time or from place to place. But regardless of the variation, it must be just. So just let me take a certain portion from O'Connor's writing on this man-made law. Under question 95 in his Summa Theologica Disputation, he titled it The Necessity for Human Laws. Quote, "From the foregoing, it is clear that there is in man a natural aptitude to virtuous action, but men can achieve the perfection of such virtue only by practice of a certain discipline. And men who are capable of such discipline without the aid of others are rare indeed. So, we must help one another to achieve that discipline, which leads to a virtuous life. There are indeed some young men readily inclined to a life of virtue through a good natural disposition or upbringing, or particularly because of divine help. And for such, paternal guidance and advice are sufficient. But there are others of evil disposition and prone to vice who are not easily moved by words, Some of us are stubborn. That's what Aquinas is trying to say. Then he continues. This it is necessary to restrain from wrongdoing by force and by fear. When they are thus prevented from doing evil, a quiet life is assured to the rest of the community, and they are themselves drawn eventually by force of habit to do voluntarily what once they did only out of fear, and so to practice virtue. Such discipline, which compels under fear of penalty, is a discipline of law. Thus, the enactment of law was necessary to the peaceful and virtuous life of men. And the philosopher says in Politics 2, that is quoting Aristotle, quote, man, when he reaches the perfection of virtue, is the best of all animals. But if he goes his way without law and justice, he becomes the worst of brutes. For man, unlike other animals, has a weapon of reason with which to exploit his base desires and cruelty. Unquote. So, to put it simply, Aquinas is saying that not all human beings are disciplined enough to be guided by the precept of natural law. And some human beings, we actually need to use fear or some force to help them to fall in line. And by so doing over time, they also come to voluntarily see the good in doing good. So to Aquinas, a law is just when it is directed towards the common good, and a law is unjust if contrary to the common good or divine good. Unjust laws do not bind man's moral conscience. So Aquinas is saying that if the law is not just, it doesn't bind man's conscience. Unjust laws are to be disobeyed. So mind you, there's a caveat. He's not saying that we should just disobey man-made laws which are unjust, just like that. There's a caveat or there's a condition. And he says that unjust laws are to be disobeyed only to the extent that disobedience thereof will not lead to scandal. In all other cases, they are to be obeyed to preserve the legal order as a whole. Aquinas is saying that even if man-made law or positive law is unjust, we ask ourselves, if we are to disobey it, what will be the consequence? Well, disobedience actually creates chaos, disorder, and problems in society, as compared to if we obeyed this law, which we know to be unjust. If the consequences of disobedience of unjust law will be greater and will be more problematic for society, then we are supposed to obey it. But if not, then by reason of the fact that it's not just, we don't have to obey it. So that's what Aquinas is telling us. So what we call the conscientious objection or positive action. For example, when it comes to the law on abortion, okay? For Catholics, for example, we think that life is sacred. And because of the sanctity and sacredness of life, it is only God who gives life, who can take life. And for that matter, abortion, you are destroying life. It undermines the natural law precept of the sanctity of life. Euthanasia or mercy killing, assisted dying, you're also destroying life. So if, for example, you are a health practitioner and you have to do any of such cases, your conscience, you can decide to withdraw from such cases on basis of the fact that it's objectionable as far as your conscience is concerned. So maybe let's revisit Aquinas just before we leave him. Aquinas talks about how we derive certain principles for, let's say, man-made law. So he uses what they call the per modum conclusionis. That is, we conclude from certain natural law precept to arrive at certain, if you like, the man-made law. For example, from do not kill, okay? do not kill because of sanctity of life. Then we have the law, the homicide, or the law of murder. So if there is a precept that we should not kill, then you shouldn't commit murder. We also have another reasoning method within Aquinas, what they call the per modum determinationis. That is determination from, let's say, promote safe travel to speed limit of 50. Yes, the principle is that we need to promote safe travel so that people are safe. If that is so, then we can say that we can put the, let's say, speed limit at a particular, either 30 miles per hour or 50 miles per hour, as it were. And this example is cited just to demonstrate to you that yes, there can be disagreements, but the disagreements that we have is not about the essence of natural law. It's about how natural law should work in specific cases. So let's say that, yes, let's promote safe travel. Okay, it's something with common good, but as whether we should fix it at speed limit should be 50 or speed limit should be 30 or should be 60. We can argue about that, but that does not undermine our conviction that it is necessary to promote safe travel. We are convinced about that, but as to how to actualize that is where we may have some disagreement. But that one in itself is not a negation of the common law, the natural law precept, which we have seen. So, Aquinas told us that unjust law is not law, and that we may disobey unjust law, provided it's not going to give rise to greater scandal. Now, in that respect, we need to distinguish legal validity in the system's terms from things like moral obligation to obey and judicial duty. So Aquinas allows that seriously unjust laws may lack binding force in conscience. Now, whether judges should refuse to apply them depends on the consequence for the common good. If, for example, there's a law which really is reprehensible, obnoxious to clear moral thinking and all that, should it be upheld or should it not be upheld? Well, if you reduce this into constitutional law thinking, one will argue that the doctrine of supremacy of the Constitution, which we have, that the Constitution is the highest law of the land and all laws must actually be in conformity, will mean that so long as the particular law is constitutionally compliant, is consistent with the Constitution, then it does not lie in anybody's mouth to say that such a law is what? Is unjust. So in a sense, the Constitution becomes, as it were, the practical concretization of what we call natural law thinking, because the Constitution becomes like the benchmark or the reference point with which to judge whether something is to be upheld or not to be upheld, as it were. I think because of time, we will draw the curtain down here and continue our natural law discussion at our next class. I think if we do probably one more class, we should be able to finish a natural law, discussion. So if there are questions on what we have discussed so far, please feel free to ask them before we draw the curtain down, and then we'll use another link to start the company law. Okay, there's no hand up, so we end this class now.